Alex here with part 223 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into my petition for writ of mandamus. Told you it was coming, and it's here. I filed it. As with my other mindset portion, I felt hopeful. I felt optimistic. I felt cautious, though, because I had seen petitions for writs of mandamus. In fact, I'd seen tons of extraordinary writ petitions get declined. That doesn't mean that the person was wrong. That just meant the Supreme Court just didn't want to consider it. It happens a lot. I think more than 50% of them are declined. Probably closer to 60%. I want to check these numbers, but I'm going to resist the urge. The mindset that I had going in aside from that was that I was really frustrated with the fact that an issue to me that was obvious could not get reviewed. I really felt like, or I really feel like now, I would not have filed this if I had not found out about the other guy's appeal. Because there was, as I mentioned in the previous video, another person who was filing an appeal over the exact same issue, except he tried to use the other vehicle, which was to file a writ of, which was to file a writ of execution. That was what he tried to do in his case, and the Secretary of Treasury resisted that. They said, we don't respond to these writs of execution. You have to do this a different way. And the Supreme Court agreed with the Secretary of Treasury. Because I saw this person have that outcome, I felt hopeful that my petition for writ of mandamus would get, recognition, because I was trying to do this thing the way that I was supposed to do it, and my judge was actually telling me to do it the wrong way, which had already been considered by the Secretary of Treasury and the Supreme Court. So it was very logical for me to decide at this point in time, I'm going to go ahead and file this. One of the things that I believe happened was there was a gap, maybe 3 to 6 months after the appeal, before I filed this petition for writ of mandamus. I'm not going to check the dates, but if somebody wants to mention in the comments the exact amount of time, go ahead. And what I think I was going to do was just let it go. I think I wasn't going to file the petition for writ of mandamus because I felt like there's too big of a chance that the Supreme Court is just not going to bother even considering it, because I had seen how often that occurs, which is more often than not, they don't even bother with it. But then, like I said, I can't remember exactly how many months later. I think it was 3 to 6 months later. I saw that other person's appeal. I saw what happened in his case. And so I said, you know what? I'm going to go ahead and file this. There's no deadline to file a petition for writ of mandamus. You don't have the 30-day constraint. And now that this other person tried this particular thing and wasn't allowed, maybe now the Supreme Court will think this is important enough to consider on writ review. So all that being said, let's go ahead and go into what I have filed. Here is my petition for writ of mandamus. Standard introductory paragraph indicating I am appearing a proper person, that I'm filing this original writ petition. Let's see. Summary. I'm indicating that I terminated my ex's parental rights. You know what, guys? This is going to be... Well, no, I haven't done the appeal because it was dismissed. Okay, I was going to say that I was going to skip through the portions that were already covered in the appeal, but because the appeal was dismissed, I didn't get to go over these. So I'm going to go ahead and continue. Terminated my ex's parental rights. She owes $500 in costs. I sought to obtain a designation of entitlement to my ex's property held in the custody of the Secretary of Treasury's Unclaimed Property Division, and I also sought to obtain the information of any and every depositor to have turned funds over to SCDU. The court refused. I appealed. This court dismissed for lack of jurisdiction. This writ petition follows. Routing statement. This should be retained by the Supreme Court of Nevada for the same reasons that I mentioned earlier, which is that it would... Oh, wait. Not only... Okay, so for the same reasons that I mentioned earlier, but I also go through this other appeal. This is what I was talking about, guys. Mr. Badia's case, this is Supreme Court number 76519, underlines the confusion and exposes a contradiction between the orders of two of the district judges in the state. Respondent in my case refused relief, rejected my efforts using available administrative remedies, and directed me to instead have writs of execution issued. But the district court in Mr. Badia's case refused relief, rejected his efforts of using writs of execution, and directed him to instead use the administrative remedies. So two different judges entering two different orders. Which of the district judges is right and which one is wrong? Relief requested. I am requesting this court issue a writ of mandamus commanding the judge to vacate its order denying the motion and enter an order designating me as entitled to my ex's property. Issues presented: whether a judgment creditor can exhaust administrative remedies in seeking to obtain a judgment debtor's property held in the custody of the Unclaimed Property Division, and whether I'm allowed to examine SCDU. Factual background. The district court entered an order granting a motion for costs on appeal, allowing $500 in costs to me and against my ex. I filed a notice of entry of order. I filed a motion for designation of wait, this is more of a procedural issue. And I'm not sure that a factual background would really need to be in a writ petition because the Supreme Court doesn't make findings of fact. They don't consider questions of fact. But it doesn't matter. They understood, I think, that this was a procedural background because they don't mention it. Okay, I filed a declaration regarding a letter from the Secretary of Treasury. The letter notified the judge that they received a letter. Okay, sorry, that they would await an order from the judge designating me as entitled to my ex's property. The judge entered an order denying. I filed a notice of appeal. I entered an order, or the Supreme Court entered an order dismissing the appeal. Okay, and then in the other case, in Mr. Badia's case, they affirmed the decision, exposing the contradiction that I bring to this court's attention, and I filed this writ petition. Extraordinary relief is appropriate. Mandamus is available to compel the performance of an act which the law requires. In general, a writ can only issue when you have no plain, adequate, or speedy legal remedy, such as an appeal. And this court has expressly held that my order denying was unappealable. My ex's residence and place of employment is unknown. Efforts to conceal herself are so extreme that in the previously litigated termination of parental rights, Department L of the 8th Judicial District Court had to order service by publication. A judgment creditor's rights and entitlements generally, statutes permitting execution against any specific types of property have to be liberally construed, which is just saying that they're in favor of allowing assets to be seized, and they want construction of those statutes to be liberal. They want flexibility in favor of seizing assets. On seizure of property held in the custody of the Unclaimed Property Division, this is the same law that I cited in the motion, so I'm going to go ahead and skip over this. There's nothing new here. And then examination of SCDU, same thing, guys. None of these statutes are new. I'm just taking it to the Supreme Court's attention. That's the only difference. Conclusion: I hereby request that this court issue a writ of mandamus consistent with the relief requested and award me costs. Verification under the law, indicating that all of the facts alleged in this document are true and correct. Rule 25, certificate of service, indicating I mailed this document to both the judge and my ex. Next, we have the appendix. I think this might be the best example of an appendix that I have on this series. I'm not going to go too far through it, but I will go through the earlier portions of it. An appendix is required in an appeal or in a writ, what do they call it? An original writ proceeding. That's what they call it. And with non-attorneys, you may not have to prepare it. If you're a non-attorney and you're filing an appeal, you don't have to prepare it. They'll just transmit the entire record. But if you're a non-attorney and you are filing a writ petition, no dice. You got to prepare the appendix whether you like it or not. If you do not prepare the appendix, you will lose. They'll just affirm the decision or whatever, deny, dismiss. They'll throw your case out. So we have here the index, which is indicating the documents and also the location of where they can be found. They're bait stamped. If you're going to prepare an appendix, you have to bait stamp the documents. You just have to do it. If you don't know how, you can Google around, find different programs that'll help you do this. I think that I'm not ordering these correctly. I think that these documents have to be alphabetical. And I think that the way that I ordered them is by date filed. So my suspicion is that I didn't order these correctly, but the Supreme Court doesn't mention anything about it. It's just my suspicion. Rule 25, certificate of service indicating this appendix was mailed to my ex and the judge. I don't think the judge needs this. I think the judge just needs the writ petition. I might be wrong. What is this here? a writ return. Okay, wait, so guys, these are the actual items in the appendix, which I'm not going to go through because all of these items we've already gone through. They're just documents from the lower courts. So standard policy in my docket series is I don't go through them twice. You can always go down in the description below, click on the link, download this for yourself, take a look at the appendix. If you see something in here that jumps out at you that we should discuss, just go ahead and let me know down in the comments, and I'll go ahead and address you in whatever way that I can. Notice of transfer to Court of Appeals. So the Supreme Court is not throwing this outright, and they are sending it to the Court of Appeals to let them decide. Sometimes the Court of Appeals does decline to consider, though. Just because it goes to the Court of Appeals doesn't mean you're free and clear. Going into the aftermath, I filed 2 documents. They were free filings. So no, wait, they weren't. The petition would have cost $250 in filing fees. So I incurred $250 in costs. Megs didn't file anything, so she incurred $0 in costs. I didn't file an appeal, or sorry, I didn't have an attorney, so I incurred $0 in attorney fees. My ex, I didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.